up. Okay, so welcome folks. This is, for those who don't know, my name is Marissa Bluestein with my colleague Kia Hayes, who's also on the call. There she is. Hi, Kia. We are with the Quattrone Center for the Fair Administration of Justice. Our center is, we have an award through the Bureau of Justice Administration, through BJA, to provide technical training and assistance to grantees under the Upholding the Rule of Law and Wrongful Conviction Prevention Program. But we also outreach with really any organizations, prosecutors' offices, or independent organizations that are doing post-conviction relief work for those who make claims of actual innocence. But this particular webinar is funded through the grant with BJA. We have these programs monthly. If you're not receiving our notifications, please send me a message. I'll be happy to add you to our list, as well as any of the other materials and programs that we have available for people. Happy, obviously, to include folks in all of that. So today's topic is part of our ongoing discussion with folks about intake and triage in particular. So by triage, we really just mean case selection. How do you move a case from an applicant writing to your organization, whether you're a prosecutor's office or an innocence organization? What are the criteria that you use to be able to say, okay, this is a case we want to move forward? You know, what is that, and what are the different kind of stages, if you will, or how flow through for a case in your organization? And how do you make a decision about the cases you want to investigate versus those that you don't? And it seems that that's a pretty universal issue for organizations that do the kind of work that you all do, is because you all have very limited resources, having to make those decisions is pretty critical to be able to try to identify cases upfront and early on, which might be ones that are ones you want to invest resources in terms of investigation and potential litigation. So we've asked a number of folks to join us today, and I'm so happy that you all could. I'm going to kind of just go through the list as it is on the screen here and ask folks to kind of jump in. So again, the plan today is to have folks I have some questions that we're going to ask them to answer about their programs, and then we'll have time to do breakout groups so people can meet in separate breakout rooms. I'm going to assign folks to different breakout rooms, and you can all ask the questions there. So that sounds okay to everyone. I'll get some nods and thumbs up. Looks good. Okay. Thank you, Jeff. I appreciate that affirmation, my friend. So I'm going to ask Tiffany and Izzy, I think, from the Georgia Innocence Project to start us off. Georgia, Izzy, you should be able to share screen now if you'd like to. And what I asked each of our panelists or guests, I should say, to address are really kind of a core group of questions. What is the flow or case selection within your organization? How did you decide on the system that you're using? What were the considerations that made you choose this particular method or this particular system? And has your new intake procedure, if you've changed it, cut down on your backlog for intake, or in other words, made it a more efficient process for you? How is the decision made of cases to move forward after application? And if we have time, hopefully, what kind of data are you tracking? And are you using the same system for data and for intake? So I'm happy to re-ask those questions for any of the folks who need them asked again. But I'm going to ask Tiffany and Izzy to go ahead. You can grab the share screen if you want. Let me pin you guys for everybody. Once I find Tiffany. There you are. I can see your wonderful smile. There you go. So everybody should have you. All up to you now. I'm going to go ahead and mute myself.
All right. Hi, everyone. I am Tiffany. I am the pro bono coordinating attorney with the Georgia Innocence Project. Izzy.
Hi, I'm Izzy Korngold. I'm a staff attorney and the case coordinator at the Georgia Innocence Project. And yeah, I can sort of start us off and then we can pivot to sort of where Tiffany's project comes in. So we use sort of a multi-tiered intake and screening process. We first send out a really short, I think it's 3 or 4 pages, I guess it's not that short, and have applicants answer some really basic questions, and at that point kind of pre-screen out anyone that doesn't meet like the most basic of our criteria. Isn't claiming innocence, isn't convicted in Georgia, isn't done with their appeals, sort of things of that nature. And when in doubt at all, we send a much longer questionnaire application that we just revamped to try and make it more accessible. So there's places in it where there's the option for sort of narrative. There's a lot of check boxes. We're doing sort of as much as we can to get rid of anything that's even a little bit legalese to try and make it easier for people to fill out. At that point, those come back. We have a group of staff members that sit down and review them and try and decide, basically, do we want more information here? Is there something that's pointing to there might be innocence, there might be something that we can investigate, and we do actually want to fully screen this case. And once we get to screening, it sort of goes to a project that Tiffany's running. But right before we get to that point, we currently, this is where our backlog is, have a wait list of cases that are waiting to be
training
screened.
section, we'll do that.
And what
Well, we can go to the.
Sorry, Izzy, that was my fault. I muted you by accident.
no worries. I'm sure there are many people who often wish they could mute me during meetings. But so cases go to a screening wait list, and what we have recently implemented is a procedure to try and figure out, okay, in what order are we handling these cases? And how are we basically making sure that we don't have a situation where it's just, oh, there's a staff member who's particularly excited about this case, or, this applicant had really good handwriting, so it's easier to read through, or sort of something that is a little bit more objective here. And so we created a ranking system with criteria that is mostly based on sort of factors that contribute to wrongful convictions that we all know. And they each, I think Tiffany will soon show us a screen, because I'm not sure if I have the ability to do that, have point values. And the purpose of our ranking system was to make this as simple and as objective as possible, so that interns can help us with the rankings, and so that if we had 5 different people rank a case, they would all come up with the same number. And then when it's time to screen cases, the cases with the highest numbers get screened first. Is sort of
Izzy or Tiffany, I'm sorry, I'm sure you're going to address this, but if you could explain to us how you came up with, I know you have point values for the different factors that you have involved. We'd love to hear about that as well, of course.
Yeah, I can speak to that. Daisy, did you have a?
No,
good-
I'll turn it over to Tiffany now.
Okay, so yeah, I'm going to share my screen in a bit. So kind of speaking to what you just said, Marissa, we originally had an older priority ranking system that was kind of loosely based on just sort of some wrongful conviction factors. And that system had been implemented when I first started with GIP a couple of years ago. What we found with that system was that, one, it took a long time to rank the cases because the type of questions that we were asking were kind of too vague for the stage of the case that it was in at that point. So like an example might be that we had, one of the factors was, is there evidence available for testing? Which seems pretty straightforward, but when you have a case that we haven't even gathered documents on yet, it's like, do you give people credit for just saying that they have evidence? How do we verify this? So things like that were making the ranking process take far too long. What we also found with our old ranking system was that essentially cases were either getting very, very high scores or very, very low scores without much differentiation in between. And so another goal of updating our system was to sort of, kind of make the ranking, it should actually reflect what's going on with the case and what we feel we can do with the case going forward. So I'm gonna share my screen so y'all can see our ranking system.
And Tiffany, as you're doing it, there's a question in the chat about whether the ranking is based solely on the claims raised in the application, or whether you look beyond the application to other materials like a post-conviction petition or maybe an appeal or something like that to help inform that decision.
At this point, we try and get everything from the actual application, and each of these factors also, we directly now ask about each of these in the application so that there's a clear place for an applicant to talk about all of these things or not, so that there's not a ton of, oh shoot, now we have to dig here, dig there.
Right, or guessing, right? Because we were kind of having to do a lot of that beforehand as well. Like, some cases we'd have more documents than others, and for some we could more easily answer questions than others. And so that's sort of also included in the instructions that we have at the top of our priority ranking here. We only consider initial correspondence that we receive from an applicant, which is generally just 1 or 2 letters. Their intake questionnaire, which is that shorter questionnaire that Izzy talked about earlier, their Georgia Department of Corrections profile, and the screening questionnaire / application for assistance, which is that longer application that Izzy spoke about earlier. And so essentially we came up, because even this is a little bit different from what we came up with when we sat down and reworked our priority ranking. But essentially we were working to update our application, and like Izzy was just mentioning, we had the opportunity to really make them line up. And so we had a larger conversation of going back to our application of what do we want to be asking, what's important to us in terms of what will make a case, what will make us want to screen a case. And so that's where sort of all of these factors ended up coming in. And so like Izzy alluded to earlier, once we identified all of the factors that we wanted to have included in our priority ranking, then we sat down and had a conversation of, what values do we want to assign to each of these, because in keeping with the spirit of being able to assign this to anyone and anyone being able to rank the case, we wanted to have it that the values, it just kind of automatically generated a rank rather than somebody having to guess and input numbers based on the answer to each of these factors. And so, for example, our first factor here is, has GIP ever represented the client, the applicant? And we assign 3 points. Generally, the more important factors on this spreadsheet assign up to 3 points. Some of the factors on the spreadsheet also take away points. So, we give a lot of credit here for an applicant that has history with GIP because their cases are older than many of the other applicants that write to us. We also, will ask if the case is located in a CIU jurisdiction. They get points for that. And we have a drop-down menu here for all of the current CIUs in the state of Georgia. And that's updated pretty regularly. What we also work to do for some of the factors that were taking a long time was to simplify them and then add some plain language explaining what we are asking for the factors, so that, again, to make sure that we're getting sort of the same scores no matter who is ranking cases. And so, for newly discovered evidence here, for example, we added some a caveat here of physical evidence that hasn't been tested post-conviction, a witness recantation, things of that nature. So there's not any confusion, not giving credit for what is an actually newly discovered evidence as we've described it. Scrolling down here a little bit more, we actually have a one of our attorneys on staff and her title is accountability counsel. So she is creating a database of bad actors that we have identified, either just know that they have committed official misconduct in cases, or applicants have written to us alleging some level of misconduct. And so for this particular factor, whoever is completing the ranking should refer to that database if there is a person that is listed there, or if the applicant mentions somebody in their application, they would give them points for this factor here. And then in the notes, list the person's name so that we have that, we already have that information as we continue to prepare the case for screening. And so, like I said, some of these factors will take away points. So one such factor is like if there's a confession or incriminating statement, but we also wanted to take into account the fact that there are a number of reasons why a person may make a confession or incriminating statement. And so even though this takes away points, we added a factor, comprehension or mental health issues. And that's a caveat there of that's only to be considered as mitigation for a potentially incriminating statement made. And so the applicant has an opportunity to get a point back there because, again, we recognize that there are many reasons why a confession might be made, but also where there is a confession and an incriminating statement in a case, that makes the case more difficult to, advocate for. So we couldn't just give like all the points back, if that makes sense. And so, yeah, we also have in our ranking sort of post-ranking factors, and we've added these here because they are important to take into consideration when we are screening the case and ranking the case, but we didn't necessarily want to bolster any one applicant or punish another one just because like maybe they're getting out sooner rather than later or something like that. But maybe, so rather than giving points to that factor, it's something that comes into consideration after the fact. So say two cases are similarly ranked, but one has been in longer than the other, then that's where that would come into consider. We would probably screen the case that the person has been incarcerated longer versus the other one.
Tiffany, I'm sorry, if I may just jump in just for a second. There's a couple of questions in the chat I wanted to highlight for people. No, because he's been wonderful about answering them. I just, in case people don't have the ability to check the chat or has some problems. The first question, though, that's not answered is, it looks like these are, I'm guessing, 19 factors or so. Are those the only factors that you use on the screening? Or is there kind of like squishy factors, I guess, that get accounted for as well?
So we tried to stay away from squishy factors because, like we said, it's our old ranking system had more squishy factors, which then led to our taking a long time to rank a case, and also oftentimes rankings being incomplete because you weren't able to, give a yes or no to give award points.
Right.
So yeah.
But you can leave it blank and then it doesn't affect the up or down. Right. Okay. Izzy, you also answered a couple questions in the chat about, for example, accounting for applicants who are more articulate or may know the right buzzwords related, as well as how you decided what point values to go to each one. And if you could just quickly answer those out loud for folks who may not have access to the chat.
Yeah, so one of the things that I put in the chat is, although these ranking factors, a lot of them are using sort of more buzzwords or legalese, and I said they do correspond with questions in our questionnaire. They're not necessarily all asked with the same words in the questionnaire. And in the questionnaire, we also try and use sort of easier to understand language and try and, whenever needed, give an extra explanation or examples of what we might be asking for.
Great. Okay, thank you for that. Sorry, Tiffany, I jumped in for you.
Oh, no, no worries. This is, again, my fault for like not paying attention to the chat.
No, all good.
So yeah, like I mentioned before, these factors, we value continuous improvement. So we're always editing and kind of improving them like this. The first factor, has GIP ever represented an applicant? That actually was added relatively recently because we had a person come back to the screening stage who we previously had a representation agreement with. And after having conversation, we agreed like we should give people credit for our having worked on their case before, and they should get a bump above other people for that reason. And so that's sort of the priority ranking. I mean, additionally, we have what we call a firm prep checklist as part of our priority ranking as well. While the case is on the screening stage waitlist, we begin work to prepare it for screening. And so we have this checklist here of pretty much all of the important documents that we'd want to request or have for any case before we start screening it. So it's pretty much everything. We'd want all of the appeal, any post-conviction filings, everything related to the case at the trial phase. So the DA's file, the defense attorney's file. Another update, and actually, we've actually updated this a little bit more since I shared this with you, Marissa, because we actually added, in addition to the defense attorney's file, what we have started doing is requesting documents from the applicants as well when they move to the screening wait list. And so we have incorporated that as part of our just sort of processes for preparing cases for screening. Essentially, when a person is notified that their case is at the wait list, we also ask if they have any documents. And if they do, we make a note in the spreadsheet as to what documents they have so that we don't go and have to request those from other people. But yeah, so that's sort of the quick, or maybe not so quick, of our internal priority ranking system. I was trying
And
to
just a couple like technical questions. This looks like it's done on a Google spreadsheet, so not a priority kind of database or anything like that.
right.
So in other words, that people could do if they were interested in doing a similar program for themselves. And then the second kind of technical question is, does this feed directly into a database or others, or do you have to transfer the information by hand?
Oh, so we actually we call it our roles and goals spreadsheet, where we keep track of pretty much all cases at the screening stage and the active representation stage. We have a screening wait list spreadsheet there, where there's a bunch of information that we have logged for each case, but one of those is what the case is ranked. Part of the instructions for completing the priority ranking is, once it's complete, the person who has completed it is to hyperlink this spreadsheet into that roles and goals, because again, it has all of the cases at the wait list. And so we can sort of quickly look through and see, what's ranked what, and, we can also reorganize the spreadsheet into, highest to lowest numbers or whatever the case may be, to be able to quickly see, what cases should be prioritized next for screening.
Excellent. I don't see any other active questions, although I'm sure there may be some coming up. Izzy and Tiffany, thank you both so much for this. I'm going to go ahead and grab the screen back so that, yep. And we've got Lorna and Rob from the Shelby County CIU. I'm sorry, it's Justice Unit, I think, if I'm not mistaken. I probably am, because I tend to get those things wrong sometimes, but Rob and Lorna, you guys are up next. Let me just move my spotlights around for folks. Where did you go? Of course, if you start talking to, that makes my life a little easier in terms of being able to find folks. There you are.
Got us?
I got Rob. I'm looking for you, Lorna.
I'm here. Funky necklace.
Be able to share screen if you want to there, Rob. I'm just going to add Lorna once I find her in here.
Okay.
But you guys go ahead.
Oh, okay. All right. We're brand new. We started November 1st, and the only full-time employees are Rob and I. So it's been really fun, and we worked really hard. We both came here November 1st, and we opened, we launched the unit on December 1st. So we were pretty quick at that, and we tried to be very thorough. And I think the first question is, what flow do we have here at the office? And Rob, since she can't find me, why don't you take up this part since everybody can see you?
Okay, so the flow. First thing is we had to develop this from scratch. And what we did is we listened to Marissa and Kia and reached out to Sunny Eaton and Valerie Newman and got form letters and files and forms. The way we work is we don't do anything without an application. So if we get a letter from someone, we'll send them an application. And then once we get that sort of basic 3-page application back, that begins our process. We open a file, we triage it. And the way we've developed it now is either it gets closed as does not meet criteria, or they get sent a questionnaire immediately. Once we get that questionnaire back, then I guess we don't call it the same thing as a screening waitlist, but that's essentially what it is. It's our second stage of review. We take a look at the closed prosecutorial file, either get it out of storage or look at it digitally, and we make a decision on what's next at that point. The triage requirements, it's something that Lorna can speak to. That's something that you developed, and I think it's probably still in development. But we do pretty much the same thing the GIP does, even though we have a different role. We don't represent people. We're doing prosecution integrity review.
Right. And I'll pick up with the triage. We developed this because we're both new at this. We're talking to Marissa and the Quattrone group, and we're looking at everybody else's. And of course, you have to decide for yourself what you need. And based on how we were talking to each other about what we were seeing, we developed this triage. And on our triage, we assign points. The issues involved are really kind of how we started. And it's, is the person incarcerated? Does it involve a juvenile? And that gets, and we only have a ranking of up to 5 points. And if it involves someone who's convicted when they were juvenile, they get 3 points, because we have a juvenile court system that has had a difficult history with children. The DOJ actually had to come to Tennessee for a while and oversee things here. So we really want to give those people a little more of a close stare pretty early on. Whether or not they have a pending post-conviction matter, which means there's ready access to a court situation already. And then we look at the possibilities of new evidence and how strong their claims are. And we kind of weight those 3 or 4 different ways, like, are they strong possibilities of new evidence and strong claims of innocence, all the way down to weak possibility of new evidence and weak claims of innocence. We also have added, and this was Rob's excellent suggestion, to add the mental health issues to a part of it. And we hadn't done that before. Again, we're kind of we're jumping through hoops as we create the hoops. So that's a kind of an outline of where we are on our triage. And I really like the triage. I think it really helps us if someone comes behind and say, why did you choose this one early on? We can go there, and it's a system that shows our best attempts to be fair and treat everyone the same. So I'm very glad we have this. It goes to the electronic file as well as the hard file when we do these.
Great. So you anticipated my next question on that, so thank you very much. Adele just points out, and which I think is undeniably true, it's much easier to assess cases with immediate access to the DA's file from the innocence organization's perspective. So the fact that you as prosecutors are taking that on right away, I think is very helpful, obviously, for your ability to kind of assess that case. And if you guys have nothing else to add, I'm going to move to Jennifer, who's with us somewhere from the Mid-Atlantic Innocence Project. We'll just kind of like go back and forth between the two here.
Marissa, I want to add one
yes.
thing.
Yes, please.
We instituted a mail log and an email log. I take care of the hard mail log, and we put the person's name, the TDOC number, and we check off, is it a new app, an app after they've been denied, things like that, because that way every single day we're charting what we've got. And we do a cumulative at the end. So we'll kind of have all of our information ready when we do our quarterly reports to say, how are we doing? How many came in this week, this month?
Awesome. So I'm sorry, Jennifer, I don't see you on here. You may not be on here. Let me check my participants here for a moment. But Clay, I do see you. So if you want to kind of go ahead and unmute, let me jump you ahead of the line a bit.
Sure.
And sorry, I thought I was getting good at this at Zoom, but it doesn't always go as well as it should. But again, start talking, Clay, and I'll be able to find you. There you are. Thank you.
Can you see my screen as well?
We can see your screen. I'm
Okay.
going to find, there you are. Hello. Just make sure that you're spotlighted for everybody. Go right ahead. You have the floor, my friend.
So great. So we had kind of created this spreadsheet in the past. So luckily enough, I get to use, or this PowerPoint in the past. So luckily enough, I get to use it again. So I'll just go through the basics of our intake process. It's a 4-stage process that was developed a long time ago, probably by Marissa. So stage 1 is essentially us receiving a letter from an incarcerated individual asking for us to review their case. At stage 1, our office manager really looks to see just 3 basic things. Was the person convicted in Pennsylvania? Do they have a sentence of 10 or more years, either probation or incarceration? And are they past their direct appeal stage? If it doesn't meet those 3 criteria, we send them a letter saying that we'll place them in our alternate letters file. If it does meet our criteria, we then send them a questionnaire and move the case on to stage 2. It's stage 2, like I said, we send them the questionnaire. The applicant fills out the questionnaire. It's about 14 pages long at this point. Once we get the questionnaire back, we also ask them for their appellate documents. So just the appellate brief, the Commonwealth's appellate brief, and then the court's appellate decision. We then assign that case out to one of our many lawyer volunteers. So we send them just the questionnaire, the appellate documents, and have them fill out a template, really detailing and summarizing the case, and then assigning it a ranking similar to the triage system that was just talked about. Then at the end of stage 2, I will review what the volunteer attorneys put together. If I believe it should be moved on to stage 3 because there's a credible claim of innocence, I'll go ahead and do that. If I think the case should be closed, it goes through multiple other sets of eyes before the case is actually closed. And we're very liberal about what will move on from stage 2 to stage 3, basically taking what the applicant says as truth, even if we don't have the documents to back it up at stage 2. At stage 3, we ask the applicant for their entire case files, so trial transcripts, police files, all appellate documents, all post-conviction petitions, and then we'll assign that to another volunteer or group of volunteers. So this will usually be our legal interns, so law student interns, or other volunteer attorneys. They will take all this information, digest that, put it into a synthesized report. And again, we'll get together as a group and look through those reports, the attorneys here. and then make a decision as to what to do, either close the case, move it to stage 3.5, or move it directly to stage 4, which is actual representation. Stage 3.5 is our investigation phase. This is where we have a case that's at stage 3 that we can't make a decision on without additional information. So we need to send out an investigator to talk with people, or do some sort of other additional investigation before we make a decision on the case. In order to move to stage 4, we have to present the case to a neutral 3-person panel who gives the final word on whether we can actually move the case on. We've had this in place because, like the volunteers, like prosecutors, like defense attorneys, maybe we could see ourselves becoming somewhat biased as we're reading through the case documents, and pushing the case forward. So we just want a neutral body to come in, and we present the case to them, and they actually make the final decision as to what we can do moving forward. So we have volunteers, like I said, it's stages 2, stage 3, and stage 4. It's a varied time commitment. It's stage 2, it's 15 to 20 hours. Stage 3 is much longer, usually around 100 hours or so. And stage 4 is actual representation, so that can vary widely depending on what the case involves. So some of the tools that we use, and this is mainly for tracking and metrics and knowing what's going on with the cases, since we have so many in our system. But this is our Salesforce kind of, when I open Salesforce, this is what I see. So it accounts for all the letters that we've ever received, the number of cases in stage 1. At stage 2, we have, as you can see, kind of a variety of different statuses within that stage. So some are not ready to assign because we haven't gotten the questionnaire back, or because we don't have the appellate documents. Some are ready to assign, some are out, and some our volunteers have already reviewed it and they're waiting on my review or other attorneys' review. And I can essentially click on any one of these things and see the entire list of cases pop up. And it's kind of the same thing, although the statuses vary with stage 3, stage 3.5, and stage 4 as well. And I
I'm sorry, if I can, let me interrupt you just for a moment. There's a question in the chat about the review committees,
Sure.
which is, who are the members of that panel? Prosecutors, defense attorneys, members of the community. And I'm assuming there's a related question, which is, how do you choose them?
Yep. So they are, there's usually someone from our board on the case review committee, as well as prosecutors, former prosecutors, defense attorneys from the community. Will generally pick people who have some knowledge, have some basis surrounding the individual case that it is. So if it's a Philadelphia-based case, we have people from Philadelphia, as well as people who can give us advice on how to move forward. If it's a Pittsburgh case, we'll have, people that we know in the community in Pittsburgh, maybe a law professor, maybe a former prosecutor, people along those lines who might be able to push us in different directions depending on what's available in that county as well. So if there is a CIU in that county, if there are different people, we should contact those sorts of things. But it's varied, all depending on what the case involves, essentially. Okay.
Awesome, thank you.
Yep. And here's just kind of a snapshot of, so the new Salesforce system that we have in place now offers a lot. So each stage essentially has its own landing page. The case itself has its own landing page. It tracks lots of different things. You can see in the bottom right-hand corner. It tracks detectives, prosecutors, you name it. If you want to go ahead and add them in and associate them with an individual applicant, then you could potentially click on the detective's name and see what other cases they've been involved in the past. The main issues that we see are actually filling in the information in Salesforce, because it can be a lot and it can be pretty tedious. And we don't have access for the volunteers to fill in this information. So it comes down to the attorneys and our paralegal filling in this information. But as you can see too, you can track the county of conviction, years of the crime. And then once all this information is in, I can essentially run a report on any of these things and pull up information on all the cases that we have in our system. Again, I would only trust their data in the last maybe 3 or 4 years regarding this information, because some of these fields are new and a lot of the cases in the past weren't tracked with the necessary detail to run these kinds of searches. And these
I'm
are
sorry, Clay, if you could just to go back a minute, because at least for me, it was a little bit hard to see on the screen. Just give a quick, like the kind of data that you're tracking there. If you don't mind.
Sure. And this is just kind of in the landing page. We track, we record the docket number, like I said, county of conviction, year of conviction, date of conviction, whether there was a DNA motion filed, if it's a co-defendant case, and if it is, we'll link the case to the co-defendant if they're in our system as well, so that we don't run into potential conflicts. We'll record the victim's name, the date a retainer was signed if they're in stage 4. We'll try to record the trial and appellate attorney names. If it's a lab analyst, doctor / expert case, if it's a potential what we call bad cop case, if it's a DNA case, and if it's a potential CIU case. So those are just the fields here. And this is just kind of some tracking that we've been able to pull from Salesforce, and it's helped to understand how we're moving cases through the system from stage 1 to 2 to 3 to 4, how many cases we're closing, that sort of information, how many volunteers are involved. A lot of this is for, our board, for potential donors, those sorts of things, but it's helpful for us as well. We, for our database, for document management system, we've recently transitioned to SharePoint. It's essentially all our documents are held here. I can right click an individual file and share it with a volunteer, quick and easy. And then everyone working in our organization can access all the different documents there too. It was a tough transition, as all of these technology transitions tend to be, but it's working pretty well now. We recently revamped our questionnaire, the help of Marissa and some other people that she referred us to, and we recently put together a new training manual. So I think that's it for at least my spreadsheet or my PowerPoint. I apologize if I didn't answer all the questions in order as they came up, Marissa, but
No, it's all you're doing great.
happy to
Great.
answer.
Thank you so much, Clay.
Sure.
Just double checking to see if there's anything. Nope. And I think our last scheduled presenter is Letty from the Minnesota Attorney General's Conviction Review Unit. So let me just find you, Letty, wherever you went. In fact, if you could unmute and start talking, that makes my life a little easier.
I'm right over here.
There you are. Okay. Fantastic. Okay, all yours.
All right. So like Marissa said, my name is Letty Usueta. I'm the paralegal at the Conviction Review Unit at the Minnesota Attorney General's Office. I handle a lot of the data management in our database. So I'm excited to talk to you all today about our case flow. And I mentioned to Marissa, I'm going to talk mostly from beginning to end, how we start off when we receive an application to the very end of closing an investigation. If I should touch more detail on certain parts of it, just feel free to prompt me. So I'm first going to share a flow chart that we have that kind of details out our process from beginning to end. And I'll be bouncing between a couple different PDFs of some screenshots I took of our database, our system, and some guides that we have created. So in order to be considered for a review from the Conviction Review Unit, we must receive an application. We receive applications by mail and also by email. We do have a public email address where at times people will email their applications to us that way as well. It must be the individual who's currently incarcerated that applies, or an attorney representing the individual. At times, innocence organizations will also apply on behalf of an individual that they're representing. Applications are available online. Otherwise, they are also available at DOC facilities, and then people can mail them in that way. So once we receive an application, our legal secretary scans the application if we receive it by mail, along with any additional materials that the applicant may have sent to us. And we do save everything both externally, and we have a hard drive. And then we also save everything in what we call our CRU case tracker, which is on SharePoint, which is essentially a sophisticated list that we've created and use as our database. This is where we track all of our applicant data, as well as where the applicant is in the process, which I believe I should be able to bounce between the different PDFs here. Please let me know if it did not switch over. But this is essentially a screenshot.
Looks good.
Excuse me.
Sorry, I was just saying it looks good.
Okay, great. Thank you, Marissa. So this is our home page, and then just a brief little screenshot I took of our tracker. In the tracker, we keep track of where each applicant is in the process, as well as storing a lot of the initial data that we collect through the intake and initial screening process, like we call it. We will be switching. The whole Attorney General office is going to be changing to a different case management system next year. So this may be changing, and we're really excited for that new update. But as of now, we are using SharePoint as our main database. So when we first receive an application, it's placed into initial screening status to be screened to make sure it meets our basic criteria, which I can go into our basic criteria in one of the further questions. Otherwise, let me know if I should get into it now. But the screening is generally done by, we have law student externs. We have student externs from law schools in a couple of different states now that we have every single semester, and I take care of assigning those out to them. Between semesters, when we don't have externs, usually it's either me or our secretary that handles doing those initial screenings. When we have new externs, we do have a guide that we created for our externs that walks them step by step through the process of finding their initial assigned applications and completing the screening and filling in the data fields on our SharePoint site. So during initial screening, basic information about the applicant, their case, and any investigative leads, arguments is all collected and entered into our system. The screener can also flag the application for potential factors of interest. For example, police misconduct, DNA, racial bias, discrimination, things of that nature. Then the screener can make a recommendation to our director, which unfortunately she had a schedule conflict and was unable to be here. But that recommendation to the director can be to either close the file, to open an investigation right away, or place the application into what we call pending review, which is that second phase, which is like a wait list essentially. So the director then reviews that recommendation and will make a final determination. After that final determination is made, our secretary then informs the applicant in writing about the decision. We generally have a deadline we set for ourselves of 90 days of when we initially receive the application to when we notify the applicant of that first initial decision. We are caught up on our application, so we're processing them much faster than that. But that's the hard set deadline that we set for ourselves, is that 90 days. And then once that person is notified, then we will change that status in the tracker. Most commonly, we move an applicant, if it meets that basic criteria, into that pending review waitlist phase. Moving from intake to directly to an open investigation is rare, but it does happen occasionally. Generally, it's cases that have been worked up already, either by an innocence organization or an attorney, or has a quick actionable lead that we'd be able to take action on relatively quickly. So then next, after that, if the director decides to place the application into pending review or our wait list, it's assigned a priority level, which the director decides the priority level 1 being the highest, priority level 3 being the lowest, and then waits for a more in-depth review, which that in-depth review involves reviewing publicly accessible case documents, such as trial transcripts. The in-depth reviews are generally also done by our law student externs, but we do also have volunteer attorneys that do reviews for us as well, or at times I do some research and some assistance in reviews as well. They're generally done set by a set of criteria that's set by the director, and that allows us to streamline our review process, filter in SharePoint for a specific batch of applicants that meet a certain set of criteria, which has allowed us to be able to get through applications much quicker that are in that pending review phase. Recent example of that is the most recent kind of grouping that we did of our pending review applications is reviewing the ones that pled guilty first, because very few of them will remain open due to Minnesota's strict requirements to overturn a guilty plea. So we were able to kind of lump those to start, and that's an example of that. When we have our externs doing those initial or those pending reviews, that in-depth review of an application, we do give them guides as well. So we have instructions that we give to our externs that kind of walks them through step by step what they need to do, as well as what to look at. And we also give them checklists to walk them through reviewing the guilty plea transcript or the guilty plea agreement, whether there was an appeal, post-conviction, reviewing any additional relevant information. All of this helps the director to be able to make a final decision. So once a pending review application is done and that review is completed, then a recommendation again is made to the director. The director can decide to either close the application at that point, move it up to a higher priority level, keep it at the same priority level, or open an investigation. And with decision, we notify the applicant again of that decision. So if a decision is made to close, we notify the applicant, and we also make an effort to explain why we decided to close the person's application. And that is then also updated in our CRU case tracker. We do have also recently created a subsite as well, because our tracker, we track a lot of information in the tracker, and we didn't want it to get too overloaded with information. So the nice thing about SharePoint is it gives us that flexibility to create new pages, to create new subsites. So I did just that and created a subsite for pending review applications, which a little bar at the top here isn't letting me see what my PDFs are. I might just have to open it separately. Give me 1 second here. Oh, there we go. All right, so our pending review subsite. So on the subsite, it's very similarly formatted to our SharePoint main page, our tracker, where we enter the information of those applicants that are currently pending review. And then this is where we also track the recommendations that are made, any additional information, store additional materials that are collected during that review process. And then we also do make an effort to keep our applicants updated every 120 days, so every 4 months that they're in that pending review phase. We track those deadlines in this page as well to make sure that we're keeping them updated in a timely manner. So once an application is reviewed by the director, if the director decides to open it for investigation, the next phase after that is first to contact the county attorney, and the victims are also notified as well that we're investigating the conviction. An attempt is also made to secure a volunteer attorney to represent the applicant if they are unrepresented. We do keep our number of open investigations relatively low because we are a very small team. It's just me, the paralegal, Carrie, our director, and then we also have our secretary who's part-time. So we have 2.5 staff people. So currently we have 12 open investigations, and we do usually keep it around that 10 to 12 range to keep it manageable. So during investigations, we request all files. So we could request prosecutor, defense, appeal file, medical examiner's file, all of that is requested. And we may go out and interview witnesses, consult experts, and conduct other research. So investigations are generally led by the director, although we do also have our law student externs that assist with research, volunteer attorneys. We also have some specially appointed counsel that volunteer to assist with those investigations. And then we do also have law school clinics that this conviction review unit has collaborated with, that has students that also assist with research in those investigations. And then, as you can see on the flow chart here, at the very end of an investigation, the director then makes a recommendation to the Attorney General. The county attorney is also notified of the recommendation, and collaboration is the goal. So Carrie really works hard to work with the prosecutors to come to an agreement and to make sure we're both on the same page about the results of the investigation and what type of relief may be requested. Once the Attorney General reviews the recommendation report, they can accept, reject, or offer some different course of action. If recommendation for relief is given the A-OK by the Attorney General, then it generally goes to the county attorney for action to then litigate in court. If it's one that the Attorney General's office prosecuted, we may also have a more active role in that as well. And then otherwise, if it's not an Attorney General's office prosecuted case and the county attorney is going to take it over, the CRU then assists however possible to help implement that course of action. But that's the very kind of quick summary of our case flow from beginning to end.
That's awesome, Letty. Thank you so much for that. So we do still have about 15 minutes left for folks on your usual time here. And we had planned to allow for folks to have some breakout room times. Happy to modify that if people just had questions or things they wanted to share in the open big group. I'm seeing some folks on here who I know have their own systems in place and probably could share as well. Pausing for a moment. So then what we're going to do is let's go ahead and just create some breakout rooms and give folks a chance to kind of talk amongst yourselves. And I will close the rooms in about 10 minutes or so. Just please remember, when you leave the breakout room, go to the bottom of your screen and hit leave room, not leave meeting, and that will bring you back into the main room. Okay, so I'm opening the rooms now. People are being just kind of thrown in. Go right ahead and join those breakout rooms. Okay, cool. Okay, if anybody can still hear me on here, we are